Good evening, everybody. I'm Glenn Wiggle here with the Financial Guys, and I'm joined by Ellen Spencer, and you are here to watch Estate Planning 103. So thank you so much for joining us. We certainly appreciate it. Before we get started, just a little brief background on myself and Ellen. As you may or may not know, myself, Glenn Wiggle, Mike Lomas, we are the founders of the Financial Guys. We started the Financial Guys back in 2000, so we've been in business now for just over 20 years. Previous to that, we spent time at a small family-owned firm and Payne Weber, which was a large wirehouse, now UBS Financial Services. I got acquired back in 2001. We went independent in 2000 and, really decided to create a one-stop financial shop that I'll talk to you a little bit about more at the end of this presentation. It's taken us, decades to fulfill that vision, but within our office, we have a number of different departments that handle a lot of different aspects of not only financial planning, but also insurance planning and things like that. Ellen Spencer is joining us today. She is an attorney, has spent 15 years in the industry with McGavran and Grimm. And Ellen's going to be talking about really doing the bulk of the presentation. I'm going to kind of walk you through this, but you've got the expertise, Ellen, and all the legal things and all the legal docs. Estate planning means a lot of different things to a lot of people. And, that's why with our TFG Academy, most of our academy sessions are like income planning is just one seminar. Retirement planning is one presentation or one workshop. But estate planning, we broke out into 4 different sessions. It's a 101, 102, 103, and 104. Today is estate planning 103, and it's going to be a broad overview of estate planning basics. If you missed the previous seminars, feel free to go to our website at thefinancialguys.com, and you can watch those seminars or rewatch them there. 101 was all about passing money on to the next generation, how to utilize trusts, life insurance, and things like that to maximize the amount of money going to your beneficiaries and minimize the amount going to the IRS. Estate Planning 102 was about protection from nursing homes and creditors and things like that. Today, we're going to talk about some of the estate planning basics, and this will cover a lot of the things that we hear that people call in for. So, when people think about estate planning, as I mentioned, everybody thinks about something a little bit different, right? Some people think about estate planning as getting my wills and stuff done. Other people talk about it as avoiding taxes. Some people have issues with special needs children, things like that. So all of those things fall into the category of estate planning, and we're going to try to cover as many of those basics as we can today. Estate Planning 104, I'll just put a quick teaser out there, is going to be specifically regarding nursing homes and protecting your assets and what you can do. We're going to bring in a special guest there as well, and she's going to go through a much more detailed action plan on what you can do to protect those assets, specifically talking about protection from nursing homes for Estate Planning 104. So stay tuned for that. That'll be part of our TFG Academy schedule for our first quarter, our winter session. So look out for that coming up after the holidays. So let's just jump right in here, and we'll start off with kind of what we're going to talk about today. We're going to cover the 4 corners of estate planning. We call it the estate planning basically the 4 corners of your house, right? So we'll get into some of those things, your wills, your trusts, your powers of attorney, your living wills. We're going to talk about probate today as well. Lots of folks are concerned about probate, and I think there's a lot of misinformation that swirls around what it is and how that process works. We're also going to review beneficiary designations. This is something that is typically free for you to update. And there's a lot of new uses for beneficiaries, and we'll talk about some of those, like transfer on death accounts and things like that. We're also going to talk about deed transfer with life estate. We get this question, I would say probably once a week from clients. Should I transfer my house to the name of my children? We're going to talk about how that works, pluses and minuses of that. And then we're going to wrap things up with just a brief discussion about trust. So we'll talk about the types of trusts that are out there, maybe a little bit deeper dive where you might use different types of trusts for different purposes. So let's jump right in, Ellen, with the 4 corners of estate planning, and really, not in any particular order, but durable power of attorney, healthcare proxy, living wills, and then the last will and testament are what we consider kind of the 4 corners of what you would need for a proper estate plan. So let's start with the durable power of attorney. So talk about, what is it? How does it work? Why is it important? I think a lot of people don't even, think healthcare proxy, but they never think about the power of attorney.
Yeah, it's true. And sometimes people are hesitant to have a power of attorney. But it's really, of the 4 things, it's really the most maybe important to have. So what a durable power of attorney is is in the event you're alive, but you're either incapacitated or you're of an advanced age where you don't want to pay your bills, or simply you just don't want to do it anymore. There are people who get into their 80s that say, I just want somebody else to do it. And it's useful for younger people too. I mean, terrible things, tragedies happen, accidents happen, strokes, things like that. So what it is you appoint an agent that you allow to handle your financial affairs. Anything really administrative. It's not necessarily, not necessarily financial. They can sign contracts. They can bring lawsuits. So a durable power of attorney is something that's really necessary, because if you have something that's just in your name alone, you have a bank account where you pay the bills that's just in your name. If you don't have the capacity to access that anymore, your durable power of attorney is really the only person who can pay those bills and handle those financial and administrative matters for you. In New York State, there is, a gift rider, which allows the power of attorney much more flexibility than just to have a basic power of attorney. But everybody should really just have a basic power of attorney, whether you have that gift rider or not. That allows somebody to handle your administrative affairs in the event you can't do it yourself or don't want to do it yourself.
Right. And today's day and age, things have gotten a lot more complicated too, right? So in the past, I used to be able to call the gas company, for example. I got an example up here, and Tom and his wife, Mary. But I used to be able to call the gas company. All the bills are my wife's name. She takes care of the bills of my household. I take care of the investing and the finances and whatnot. Right. And but if I go to call whatever, electric company, they won't talk to me anymore.
Absolutely not. So
it's gotten out of control almost, to a point
it
where
is. It's much more difficult, even particularly for me. It's difficult to practice law and find things out, because Anywhere is very hesitant to speak with anybody on anybody else's behalf unless they have a document that either gives authorization or you have the power of attorney. You're right. The gas company, the cable company, nobody's going to talk to you if you're not that person. All of that sort of came with 9/11. It came with the Patriot Act and Privacy Acts and things like that. So that's sort of when that started. But the power of attorney does allow the agent to gives them the authorization to find out information and to sort of handle the administrative stuff on your behalf.
So we always use a durable power of attorney. I know that's what you guys recommend. There's also the springing power of attorney too, right? So
in New York, we don't have springing powers of attorney anymore.
Oh, in New York, we don't. Okay.
No.
Every state.
So in other states, they do.
Okay.
And all powers of attorney starting in 2009 in New York State are durable, meaning they are good the second you sign them, whether you're incapacitated or not. The reason there is no springing powers of attorney anymore, and just the difference to explain, durable means it's good all the time. Springing means it doesn't take effect until you are incapacitated. Doctors and medical professionals were very leery of signing something that says you're incapacitated to sort of put that power of attorney into effect. Gotcha. So New York did away with the springing, but there are springing powers of attorney in other states.
But you wouldn't recommend those typically?
People do like them. People who have no children, who say, I'm going to handle this until I absolutely can't do it anymore. I do get the question that says, I don't want anybody just to be able to do what they can do if I sign this document. But in certain circumstances, they're okay. But a durable power of attorney is really the most useful.
Yeah, better option, I think. All right, let's talk about the healthcare proxy. To me, this is super important. And this is something that I think that everybody needs to have one of these. Now, you go to the doctor, you go to the hospital, they've got forms there they can hand you. Explain the difference between having your own and using one of those, and why it might be more important to have one of your own.
Sure. So the healthcare proxy is that an attorney prepares is universal. It's tailored to you. It's not just the Department of Health form. I tell people frequently, just because you filled one out at a hospital in a hospital system somewhere doesn't mean that it's good everywhere. You might have to call that hospital system and they may say, we don't keep it on file. So if you're at a different hospital, it's not good. Having sort of a universal healthcare proxy where you nominate this one particular person to make the decision for you is really the best course of action, because it's tailored to you. It has all the proper information. It was witnessed properly, all of those sorts of things.
Is it good cross state lines? And we just talked about the.
It is.
What
So,
I mean, in
the United States, we have something called full faith and credit, right? So if it was properly done in one state, it's good in another state. As far as the healthcare proxy goes, that shouldn't be an issue. The powers of attorney, if you change residency, so let's say you move from New York to Florida, or you move from New York to Arizona. If you're going to become a permanent resident of that state, you should have a power of attorney and a healthcare proxy for that state. It doesn't mean your ones from New York or Massachusetts or wherever aren't good, because we do have full faith and credit in the United States, which says you have to, one state has to recognize the other state's documents. But banks can be difficult, as we know. And it's going to be a little bit more of an administrative hassle, let's say, if you have an out-of-state power of attorney.
Gotcha. All right, living will. This is something that confuses a lot of people, but this really goes kind of along with the healthcare proxy, right?
Sure. So a living will, what it does is it is for end-of-life decision-making. It gives guidance on, the particularities of what you might want and what you might not want. Ultimately, you are giving the power to an agent that you appoint to make that decision for you based on what you have laid out in your living will. Many times it'll say, keep me comfortable, pretty much. And it'll lay out some of the things that you want and don't want. If you don't want to be, on artificial, heart-lung machines or things along those lines, then it gives your agent that you appoint guidance on what you might want or not want.
Is it required, or can the healthcare proxy stand by?
Living will is not required. In certain states, in New York State, your healthcare proxy that you appoint, as long as they reasonably know your wishes, can make that decision for you. Certain people have very particular end of life sort of, whether it's religious, whether it's whatever, they have very particular circumstances. In which case I say either do a living will, or generally your state's Department of Health will have a form that becomes a medical order that you can fill out if you have very, very particular reasons. You want certain things, but you don't want other things. In New York, that's called a MOLST form. It stands for a medical order for life-sustaining treatment. And your doctor signs it. So either a living will or that form will give your agent guidance on end-of-life decision-making.
So kind of like a road, you're giving the healthcare proxy gives somebody the power to act on your behalf. Mm-hmm. The living will kind of gives them some guidance as to,
Correct.
Instead of giving them discretion, here's what I want you to do or not do on my behalf.
Right.
Which makes sense. All right, let's talk about the big one. This is a biggie. This is the last will and testament. And honestly, I'm really surprised at how few people have their wills updated properly. And I've been in business for 25 years. I know you've got decade plus in the industry as well. I have seen absolute travesties because of the lack of a will or a document. I think people talk, they don't understand the way things work. They think, well, it's just my wife, everything's going to go to her. Right. But that's not always true, right? Yeah. So maybe we can start there and talking about, what happens if you die without a will. I mean,
sure.
I think, again, that misconception is all goes to your spouse, right?
Well, if you die without a will, it's called intestate succession. And a law, a statute in the law book lays out where your assets go. Now, there are, and I start out, whenever I sit with people, I start out with what is a probate asset and what is a non-probate asset, right? Many people think that non-probate assets go according to their will when they do not. Probate assets are things that are just in your name by yourself, right? So if I have a bank account that's only titled in Ellen Spencer, I have an individual account with you, Glenn, that's only titled in Ellen Spencer. It doesn't have my husband on it. It doesn't have a TOD. It doesn't have a named beneficiary. those are the things that are going to go through your will. And when people have very, specifically crafted estate plans, those are the things you have to talk about. What things do you want to go by way of beneficiary designation? Because a beneficiary designation is just a contract between, you and the custodian of the assets, and that says, this is where the money goes when I die. So people who have really carefully crafted estate plans have to figure out what are non-probate assets and what are probate assets. Are they going to go to different people? So intestate succession means that there is a formula, if you die without a will, of where those things that are titled and just in your name are going to go. So I'll give you an example. In New York State, if you die without a spouse and without children, it goes to your parents if they're alive. And that happens more frequently than you would think.
Yeah.
Bob was never married. He has no kids. He thinks it's going to go to his siblings when he dies. So why bother have a will? Right. But really what happens is it goes to mom, who's 85 years old, and maybe that's not the best, right. The best plan. Yeah. So different states have different rules of intestacy, but they're pretty similar. If parents are alive, it can go to them. If your spouse is alive, it can go half to the spouse and half to the kids. So there's a different formula in the law of where it goes if you don't have a will.
But never a great idea, in my opinion, I'm sure you would agree, to let the state make a decision as to where your assets are going by some
Absolutely not. The other thing too is you have to figure out, if you don't have a will, not anybody, but any family member who's in a line of succession can act as the administrator. And in New York State, at least, they have to be bonded. You have to go get an insurance policy to be the administrator of somebody's estate.
Right. So there's a lot of other, issues when you should be updating your things as well. One of the things I see is, one of the things I did in the very first, when I got married, and in fact, it was with McGavin and Grimm, Bruce Renoso, at your firm, actually, was the very first will that I had. And then I had children, obviously later once we were married, and I updated the will again to include, things like guardianship clauses and springing trusts, things like that. But now, as we just talked for the presentation, I'm going to have, by April, I'm going to have 2 children that are no longer minors. I've got one who's a junior in college and one who's a senior in college. And so, neither of those children now need guardianship provisions anymore inside of the will. So what are some of the other circumstances that might trigger you to update a will? Because I see some of these things that are so old that, on one piece of paper with no witnesses, I think to myself, did you write this? Is it going to hold mustard even? Is it going to fly?
No, it's true. I tell people, look at it every 5 or 6 years, make sure it still works. Yeah. Because sometimes, other things that happen, people die. If I leave $10,000 to my sister, and she passes away, is there a provision that says that $10,000 goes to her kids? It just lapses. The other thing is people don't realize is an accumulation of wealth. Sometimes people inherit money. Sometimes people, all of a sudden they think, yeah, I'm doing pretty well. And they paid off their house and their house is worth $500,000 and their insurance policy is worth $1 million. People don't realize how fast sometimes you can accumulate wealth. So those are times that you have to think about it and say, well, my kids are older. Now I have grandkids. Do I want to provide for grandkids? Sometimes I meet with people that say, my child, makes $2 million a year. He doesn't need my money. So I want to give it, to somebody else. Yeah. So, there are definitely circumstances, any big life changes, that's when you should review everything. And I tell people every 5 or 6 years, take a look at it and see if it still works.
Yeah. Getting back for a second to the dying without a will, and money going to the parents, we had that situation and it worked out well, fortunately, because the father did the right thing. But you had a child, sadly, that passed away, 45 years old, had done really well for himself. So had, established a $2 million estate. Really had, I think the intent was to go to his other sibling, sister and brother. The parents, the mom, is fine, raised the kids. The dad split when they were kids, when they were babies. So not ever in the picture, never around. And suddenly he's in line to now receive $1 million. The mom's in line to receive the other $1 million, right? And fortunately, in this particular circumstance, it worked out okay. The father did the right thing. Didn't have to, but did the right thing and disclaimed the assets, and those other assets went to the other two siblings as intended.
But you don't want to rely on that, because
No,
90% of the time that's not going to happen.
right. He could have been, that was like winning the lottery. He could have walked away with that money, and
Yep.
and it was rightfully his legally. But again, that wasn't a stand-up guy at the time apparently, but later in life, maybe just matured, and but thank God, because otherwise there would have been, half of the estate that would have gone to somebody who he didn't even really know,
Right.
and that's a disaster. So again, just make sure you're paying attention to all these things. Naming an alternative executor, getting back to, looking at it every now and again. I've seen this happen as well, where a person dies and then the executor, it also happens to have predeceased
Right.
that particular, right? So
Sure.
important to, I think, have an alternative, right?
Absolutely. And sometimes you want to name somebody who's younger than you. I mean, it's just statistics, right? It's just numbers.
Yeah.
I spoke with some clients yesterday who have accumulated a fair amount of wealth. They don't have any children. They have some philanthropic bents where they want to give some money to charity, some nieces and nephews, things like that. And they say, well, I want to name my brother and my two brothers as the executors. And I said, chances are that they're going to predecease you. Maybe throw in a nephew or a niece in there, somebody who can act as the alternative in the event that it just doesn't happen. And people don't think of those things.
Should you tell them or get permission in advance if you're going to name somebody like that as your executor of your will? Or
you don't have to.
Advise them?
And a really important thing is appoint the right people as fiduciaries, right? A lot of times somebody will say to me, well, John's the oldest, so I have to appoint him. And I say, no, you don't.
No.
Somebody who is organized, they don't have to be an accountant or a lawyer or whatever, but somebody who can communicate with the lawyer, understand things. Sometimes somebody will say to me, well, I have a son who's an artist and I have a son who's a CPA, but I'm going to appoint the artist because he's older. And I say, maybe that's not the right choice.
Right.
It's personalities matter.
Yeah.
And certain bents on certain things matter. So it's always important to appoint the right fiduciaries too.
Yeah, I agree. If your oldest is traveling the country in a rock band, God bless them.
Right.
But may not have the time even. I mean, sometimes it's a time issue, organizational issue, all kinds of issues. So.
Oh, that's true. I have clients who have sons and daughters who are physicians. And I say, and 4 kids. And I say, they may not have the time to do it.
Right.
So.
A couple of things quick. It's important, I believe, if I'm not mistaken, to have affidavits, original witnesses along with your will, right? Is that required?
It's important to have a duly executed will. Courts will admit wills to probate that are not attorney prepared. They do have higher burdens to get those wills admitted to probate. In New York State, if your will is attorney prepared and attorney witnessed, it's presumed valid. Where if you have a self-prepared will that's maybe not executed properly, it is not presumed valid. Yeah. So if you have issues, or you foresee an issue, kids don't get along, you have an estranged child, you have a fair amount of assets, go see a lawyer. It's not horrifically expensive. It's not painful to do, but it will solve a lot of problems down the road.
I would say
affidavits by the witnesses and having a duly executed will is really important.
Yeah, I would say if your kids aren't getting along and there's going to be issues, that's when I think you start looking at maybe using a trust, and we'll talk about that.
That's true. That's true.
You avoid some of those issues where Billy's going to contest this thing. It's going to be a disaster, right?
You do avoid some of those issues, and I agree with you that trusts are a reason to do that. In other instances, though, sometimes you want the protection of the court. Sometimes you want that court order. So, it's true that trust generally, if there's an issue, generally can sort of help that scenario.
Awesome. And then the last thing, and within the will, of course, you can set up, different springing trusts and things like that. Some things to consider, if you've got that spendthrift beneficiary who is going to blow through that money. If you've got a special needs child, we see this oftentimes, and this is where I think people make a big mistake. I'm going to leave Susie's share to Sally because Sally's going to take care of her sister. What are your thoughts with that?
I don't love that. I mean, I have, once in a while it's okay. Once in a while it's Susie lives with Sally.
Right.
And Sally, she's lived with Sally for 15 years. And in those instances, you want to be practical, right?
Yeah.
If it's a pain in the neck for Susie to run the trust and Sally lives with Susie, fine. I'm all about practicality.
Right.
There's no need to overcomplicate things.
Right.
But supplemental needs trusts are a really great tool. I mean, people don't realize that if somebody receives SSI, and they don't have to be terribly disabled to receive SSI. A lot of the times I see people who just can't stay employed for one reason or the other that receive SSI, that live by themselves. But what people don't realize is if you leave them $100,000, they're going to get thrown off their benefits and not receive. And it's not just that they don't receive their $600 or $700 a month. It's that they lose their Medicaid, they lose their health care, they lose their prescription coverage, that kind of stuff. So supplemental needs trusts are important. They're not difficult to stick in a will. They're not difficult to set up. And they work out great for people, allowing them to keep their benefits.
Right, exactly. One last thing on this point, and this is actually from an existing client that I've been meaning to give you a call and ask you about. And I think this probably happens more often than we think. I've got a client now who has no family left, literally. He's got no living family. The executor of his will, who was younger, was a cousin, sadly passed away like the age of 50 from cancer. So right now he has a will with no actual executor.
Right.
So two questions there. If he dies with the will as it is, with no executor, what happens? And then the second part of that question is, for somebody who doesn't have anybody and maybe doesn't have a friend network or maybe is a solitary kind of individual, do attorneys or does your firm act at times as executor or administrator for somebody's will in that situation?
Yeah, absolutely. I mean, it's funny that you should mention that. I was at I was the executor for a same thing, no family. The closest relative is a sixth cousin in Canada.
That's exactly the situation.
So I was at his house. He died, 6 or 7 months ago. I was at his house today, sort of getting some stuff out of there and getting it where it needs to go. So lawyers do will act as executor. It's nice if he has a long-standing relationship with his lawyer, it's nicer, right? It's not like you're just appointing some random person. So you really want to establish a relationship with somebody so they really understand your wishes, and check in once a year with them saying, this is how things are going.
Well, he's heading your way, so.
Pardon me?
He's going to be heading your way, so we'll get you guys together in a couple of weeks.
So, so that's one of the nice things. Or, sometimes somebody will say, I don't really have a relationship with a lawyer. If he did my will, but we don't really know him, or she, I don't really know her, but I've used the same CPA for 35 years. Sometimes CPAs will do it, or, family friends, that kind of thing. And I encourage anybody who they're comfortable with, who feel like they can sort of do the job. If you die without an executor, the public administrator becomes your executor. So the public administrator is a appointed individual who will act as your executor, and it's kind of impersonal, right? So your personal property, they just go in and sell everything. They list your house, so it's sort of an impersonal sort of transaction that you really only have if you absolutely have to.
Gotcha. Now, is there like a list that the people volunteer for the courts or something, or do they have?
No. So there is one person appointed for each county. So in Erie County,
person, I would guess.
Yeah. So in Erie County, there is one individual who acts as the public administrator. And that's in New York. In smaller counties, in New York at least, the county treasurer will act as the public administrator.
I hope they pay that guy or girl a lot, because that seems like a lot of work.
So it's statutory, actually. They receive 5%.
Okay. All right. So they get a decent, okay, that's good. I was going to say, because honestly, I couldn't imagine signing up for that job. It's a lot of work. So.
It's a lot to do.
So let's move on to probate. Let's talk about probate, and I know we can go through wills. One last thing on wills before I just to mention the guardianship side of things, and this is where I think a will can be the most important thing. We had a situation 20 some odd years ago now, sadly, where the husband and wife was killed in a head-on car crash. Yeah. And you may remember this. This is back in 1998, 99, I think, leaving a 1-year-old baby. And we had written the life insurance on the family, thankfully. So there was some assets there, but there was no will in place. Yeah. And a custody battle ensued. And sadly, it went on for years, and it really tore apart the family. And
it really, that situation is really sad.
Just
sometimes I'll talk to young people, right? People in their late 20s, early 30s, and they'll say, why do I need a will? I don't have any. And I'm like, well, you have a kid. So,
right.
Sometimes that's the sole reason.
If you have children, you have to have a will, and you have to have guardianship provisions in there as to what you want to happen with those children. I can't, there's just, anything beyond that is just negligent because, of course, the families both have the best of intentions at heart, right? They both want to do the best they can to take care of the child and raise it, but it just never works out without having written instructions. You just have to have them. So I just can't stress that enough. All right, moving on to probate. We touched on this a little bit already. It's not the end of the world, right? But talk about the process, how it works, and really kind of what the costs are overall.
Sure, absolutely. So at least in New York, it works a little bit different. In Florida, it works a little bit different in other states. In New York, if you have a fairly straightforward will, and by straightforward, I mean, there can be a trust, there can be, things along those lines. As long as everybody sort of gets along, you don't think it's going to be contested, everybody's treated equally, things like that. It's not a terrible process, right? So it's a petition for probate that the petitioner is your nominated executor. They're the one who signs all the documents. And what happens is everybody who's an interested party gets a copy of the will and what's called a waiver. So, if they sign the waiver and the petition for probate comes back and all the interested parties, sign a waiver that says, I'm okay with this will and I'm okay with this person that's nominated, there's no court appearance. There's no, you send that over with the will and a death certificate to the court and that person gets appointed. And if there's a trust, they get letters of letters testamentary for the executor, letters of trusteeship for the trustee. You can establish the trusts. It's not an onerous, terrible process. There is a filing fee. It's a couple $100. It depends on how much is passing through the will. If it's $500,000, the filing fee is $400 or $500. It's not, ridiculous. If you think that there's going to be a will contest, if you think something along those lines, probate can get a little bit more difficult. If there is somebody who says this person should not act as the executor, they stole money from mom for 5 years, then it becomes an issue. Then it becomes this person's maybe not eligible to become the executor. You have somebody else that wants to be the executor. And then you get lawyers and multiple lawyers, not just one, and you get appearances before the judge and it can go on and on. That is really the rare circumstance. I probate tons of wills a year. If I probate 100 wills a year, 97 of them don't have an issue, right? There's probably 3 that do, that there's some litigation, strange things happen sometimes. And sometimes that's just unavoidable, whether you have a trust or you have a will. Yep. But it's not terribly onerous. If it's more of a basic proceeding, more kind of basic assets, things that can get sticky if you die owning a business, you have interesting, bizarre assets, things like that. People think, something's more valuable than you do, and you have to get into valuations and things like that. That's where it can get, and everything can be resolved, if the parties are reasonable. Sometimes you get somebody who's unreasonable and you just can't avoid it.
Right.
So I'm looking at the next one. It says, don't confuse probate with administration. Right. So probate's when you have a will. Administration is when you do not have a will. And that's sort of what we talked about before. Certain people are entitled to act as the administrator. It is not someone you choose. and they petition the court for an administration. You have to determine what the assets are. That person has to be bonded. You have to go to an insurance company and get a bond. And for maybe good reason sometimes, right? It's just this random person who's going to be controlling all your assets and distributing. But I'm looking at your next bullet point here where it says you can avoid probate altogether if you properly structure your assets. Sure, absolutely. Yeah. So if you have 2 kids, you have a son and a daughter, and you have a brokerage account with you, and you have a life insurance policy, and everybody gets along, and you want to name them as the beneficiaries of a transfer on death and beneficiaries of the life estate, or excuse me, of the life insurance policy. Great. That is a really easy way to do it.
So that rolls us right into the next slide perfectly. And today there is a form for everything, right? 10 years ago we didn't have transfer on death accounts. Right. Really, I don't know if there was a legislative change or I don't know what happened to bring these things forth, but suddenly we went from, you have a non-qualified account that's going to go through your estate. Oftentimes clients would I want to add my daughter or my son onto this account just so it goes to them. We never recommend that. That's always in my opinion, that's really not a great way to go. Right. But now we don't have to worry about that, because now we can just pull out that transfer on death form and we can fill out a beneficiary. Now the beneficiary designations supersede the will, right? So they're going to be a separate contract, right? That's going to go directly to that beneficiary. But it allows you to really specifically define which assets to go to which person. Sometimes the will is an easier way to go. Sometimes the way, beneficiary designation is the way to go. And so it does make life a little bit easier at times, depending on what those assets are. So we use it for all kinds of things. One of the key things, though, I got to just mention here for folks with beneficiary designation is, just like your will, you have to keep them updated. And I know, Ellen, you got probably a pile of stories on just tragedies. I know I do. We talked about a couple before the presentation today. And, we had a situation where a $2 million account, because they sent them the beneficiary designation, the company rejected it. But they never found out. They didn't. The company didn't, and shame on this company, by the way. It's one of the largest brokerage companies in the country. I won't name them, but shame on them for not sending out a letter or reaching back out. They just threw it in the garbage, like, this doesn't qualify. And so they never. So it's really important. If you do change your beneficiaries, you have to follow up. You should receive a written letter back from that brokerage, that life insurance, that annuity company, that says, here's your update for beneficiaries. If you don't get that, you need to call and verify. Lots of
Absolutely.
things in life.
And every financial firm is different. Every beneficiary form is different. Every way they do it is different.
Right.
I had a situation recently on some life insurance where one of the beneficiaries had predeceased, and there were 4 different policies at 4 different companies. And some of them, she predeceased the individual whose life insurance policy it is. Some of them, half went into his estate, and half of them, it went to the other beneficiary. Right. So it's interesting what their policies are.
Right. Divorces, new marriages. I mean, we've had assets, we've had ex-spouses on as beneficiaries, and now the clients, newly married. We always try to bring these things up with our clients. We do 6 months reviews with our clients. We're asking these types of questions. Any personal circumstances change. So as soon as there's a triggering event, as we do these 6-month reviews, if a client says, yeah, I just got a divorce, or yeah, we just had a new child, or whatever, we're gonna make sure that, that's gonna trigger in our brain, hey, we should grab your beneficiaries, review them. That's part of our ongoing checklist. At least, be aware of the fact that, life changes, and you've got to, if you're using beneficiary designations as a way to pass money upon death, then you really got to make sure you're right on top of these things and make sure.
And you really have to understand the forms. I mean,
you really do.
It is just as important as making sure your will is correct.
Right. Utilize a financial professional for that. I mean, honestly,
Absolutely.
We work with all the companies. If it's not us, I mean, if you have a good professional, if you're working with a good investment professional, they should be willing to help you even on things that they don't control or have under them. But I'll give you an example. Certain products and certain things we could just take over, right? You have a brokerage account, we could take it over. You've got an annuity, we can do a beneficiary change or an agent change. But we can't do an agent change on a life insurance policy, right? So that's a different animal, at least for fixed life insurance. So, but we can service it, right? Well, if you go into your investment professional and you had bought a life insurance policy from somebody else maybe, and they say, well, I didn't sell it to you, I can't help you. That's not the right answer, because we all, even if we don't work with that particular company, we could usually call the company, get the right forms, and help our clients fill out those forms, right? And make sure they're proper. We can even follow up sometimes, not all the time, because again, going back to HIPAA and all the privacy stuff, they won't share that information with us oftentimes. So, but what we'll do sometimes is get the client on the phone and we'll double check, we'll make sure we got the forms, or we'll ask the client, hey, when you receive this, the confirmation, please copy us on that so we can stick it in your file as well, right? So, we can help you with that. We know all the forms. The staff is, we've got thousands of clients. So, we've worked with just about every company out there. I can't imagine that we would, we'd see a form that we hadn't seen in the past. But, and you're right, just as important as well.
Right. And a good financial professional will sometimes call me and say, hey, is this okay if I do this?
Right.
I mean,
that's important.
I have, people who have some significant wealth, who I have tax trusts for either in their wills or in their trusts. And I have their their finances structured a certain way so they fund the trusts, right? So, and that trust may be under the will, that trust may be under a separate trust. But, I had a bank call me and say, they have a brokerage account with us. I'm just going to make it transfer on death. And I said, no, you can't do that. It has to fund, we've done this, so it funds a trust under their will for tax reasons. So, there are times that you have to be really particular about things.
That's a super important point you bring up, and why we do the seminar together. And I'll talk a little bit more about this at the end of the presentation. We work in teams, right? So whether it's a group of financial professionals, or we're bringing an accountant or a CPA, or we're bringing an attorney, we have our financial or our attorney network now with you and some other folks as well. It is super, super, super important to make sure that whatever team you're working with is working truly as a team, because right on our homework, when clients come in, we're asking them, who is your attorney? Who is your CPA? Who is your home and auto agent? We have our own home and auto company now that we do that in-house. But even if you have it at, I got an agent I've worked with for years, that's fine. But, it doesn't do any good if we do a great job at building wealth for you and then you don't have the proper insurance, you get sued and you lose half of it, right? Because you didn't have the right liability limits and things like that. So all of those things are really important to have a comprehensive, cohesive plan, especially if you have wealth. If you've got a couple $100,000, again, you're not doing fancy, trusts and avoiding estate taxes and things like that. But if you've got a fair amount of wealth, and I would say, $1 million plus, now you start to get into, really, looking at taxes, looking at the legal side of things, and you got to have a team approach. We work with CPAs and attorneys that are not within our network all the time, no problem. My father and my uncle were CPAs for 40 years. So I get that side of the brain very, very well. And we
particularly one thing that is really difficult for clients to understand are the deferred assets, the IRAs and the inheritance and all of that kind of stuff. I mean, that's hard for people to understand that, these people should not be taking a lump sum of money when somebody dies.
Right.
So, those, you really have to work with the financial advisor to make sure everything's,
Absolutely
how it's supposed to be.
All right, this is the big one. I probably get this question every week. Mm-hmm. And I'm sure you do as well. This is the transferring my house to my kids. Talk about how that works, and then just kind of a brief pluses and minuses. It's not really complex, right? So.
No, it's not. I mean, it's a little bit theoretical sometimes for people to understand. It's not, sort of a concrete thing. But when you own a piece of real property, you own it forever. It's, it's one of the first things you learn when you go to law school. It's called fee simple absolute. So you own a piece of property forever, but you only live, a short amount of time, right? So what you're doing is you're retaining a life estate, which says, as long as I'm alive, I have all right title in this property. But after I die, I'm giving that share to my children, right? So we prepare a deed. It's done by deed. It's not expensive. To record it is not, an expensive operation. To prepare it should not be an expensive operation either. And it's an easy way to preserve some assets in the event you have long-term healthcare costs, right? So it's, giving your kid what's called the remainder interest, the interest after you die in the house, is considered a gift. So it is subject to the 5-year look back. But it's an easy way that you can preserve some wealth for your kids, which a lot of people, their biggest asset is their home, right? So it's generally for, 90% of the time, it's for your primary residence. And you retain the life estate, you give the remainder interest to your kid, it's kids, children. It's done by deed. It's recorded in the clerk's office. And the best part about it is that if you decide that you want to sell the house and keep all the assets, you can reverse the process. The kids just deed it back. It's not horribly expensive. It doesn't tie up the money in an asset protection trust or anything like that. And it can be reversed. It's an easy way to preserve the value of your house in the event you make it through the 5-year look back and have some pretty significant long-term health costs.
Any negatives that you can think of?
What's that? Any negatives?
Any negatives, yeah. Any drawbacks?
No, not really. I mean, you preserve your property tax exemptions, which is good. If you decide to sell the house during your lifetime and keep it as is, meaning the kids get their fractional share of the value of the house, they have some capital gains tax because it's not their primary residence. So, there are some things that one of the really awful things that have only happened once, I had a child refuse to deed it back.
Really?
Really. You can put a power of appointment in the deed that says I can change who the remainder beneficiaries are if I want to, meaning you could take that child off and, but that's one of the drawbacks is that one time, I had somebody say, no, I'm not deeding the house back, which is a very rare circumstance. I've probably done 500 of these. It's maybe happened once.
I would say that I would think that I would be writing that individual, my child, off the rest of the will. Right?
Right.
This is a team approach, right? Family team, right? So I always tell my kids, family team, right? Anyway, but yeah, those are rare circumstances. They always have that one black sheep in these families.
You always do, especially in big families. I always say there's always one.
Always, yeah, especially in big families for sure. All right, let's just wrap this up and talk about, trust. First of all, what is a trust? How does it work? And let's just talk some, uses of it overall if we can.
Sure. So there are millions of different kinds of trusts. I mean, not millions, but, there's certain trusts for certain things. What we're talking about here is primarily a revocable living trust. What a revocable living trust does is it is a tool to avoid going through the probate process. And there are certainly reasons to have a revocable living trust. One of them is I have another house out of state, right? I have a house in Florida. I have a house in Colorado. I have a house in Arizona. That's a good reason to have a revocable living trust. I frequently do them for people who have beneficiaries who are not US citizens, right? So I have a client, he is a specialist physician. He has 2 children that live in India. So we have a revocable living trust for him because it's an easy way to transfer it to them upon his death. We don't have to go through the court. We don't have to have them have documents notarized, those kinds of issues. The downside of a revocable living trust is that it's more expensive to set up when you're alive, right? Whereas a will costs you, not a significant amount of money, and it's easily done, and the pain in the neck of the transfer is after you die, right? So a revocable living trust is difficult to set up when you're alive. One, it's a longer document. There's more things to sort of think about. You're the trustee while you're alive. And you have to title everything that you own in the name of the trust. Your real property has to be redated into the name of the trust. Your bank account has to be changed to, instead of Ellen Spencer's bank account at Bank of America, now it's the Ellen Spencer Revocable Trust account at Bank of America. Right. You can name your trust as a beneficiary on things. That way you don't have to change it during your lifetime, but it goes into the trust upon your death. That's for certain sort of, financial things. Sometimes people do that with life insurance. So I tell people very frequently, if you are a candidate for a trust, you have to realize that there's some work during your lifetime that goes along with it. Right. It's a pain in the neck while you're alive, whereas the will is a pain in the neck after you die. Sometimes people say, I'd just rather deal with it after I'm dead, or not deal with it, rather.
So for the purpose of this presentation, you've got, revocable, right? We just talked about that. Then you got irrevocable or irrevocable, right? However you want to pronounce it.
So irrevocable trusts, there are a couple of reasons to do a irrevocable trust. Yep. If you have a significant amount of wealth and you are looking to get some money out of your personal name that will grow tax-free for estate tax purposes, that's a reason to do an irrevocable trust. I'll give you an example. The New York estate tax limit is right now it's 5.85 million, right? If you're a single person and you have $9 million and you want to, in the federal, it right now is 11 and change, 11.4 or whatever it is. So you have the room to transfer $4 or $5 million into an irrevocable trust. It'll grow estate tax free because you already made that gift into the trust. And then you're under the New York State estate tax limit. So people with significant wealth, I frequently write irrevocable trusts for. Another reason to do an irrevocable trust are asset protection trusts. Those are generally for Medicaid purposes, nursing home purposes. The gift into the trust still has to make it the 5 years because you have that 5-year look back, that 60-month from date of application for Medicaid look back. But what it does is it puts some money into a trust for the benefit of your kids. You cannot revoke it. And when you die, it pays out to the kids and it's not available to pay for nursing home costs, making you eligible for Medicaid.
We might use an irrevocable trust for a life insurance policy as well, right? Sure. That's another way we use it, just so that we're not adding to an estate tax issue already. So
absolutely. So fairly large life insurance policies. And by fairly large, I mean, I've seen them 500,000 and above. If you have 100,000 or 250,000, it's generally not something you need a life insurance trust for. But if you do have a large life insurance policy, a trust is a great way to get that money out of your estate and then have it, it can go in further trust if you wanted to, meaning after you die, it doesn't just have to pay out to the individuals. It can be held for grandchildren, children, as long as the person thinks it's necessary.
So a shameless plug here for our TFG Academy. We will be doing a 200 level series after we're done with 104. So the next in our estate planning series for TFG Academy will be a 104, and that's going to, as I mentioned earlier, is going to be specifically about nursing homes. But after that, we're going to be going into the 200 level classes. So we'll be doing 201, 202, 203, and 204. And during that more advanced workshop, we'll be drilling down more specifically on all the different types of trusts, the special needs trust and the generation skipping trust and all these different types of things. That will be certainly a more narrow range, I think, of the folks that would want to participate in something like that. But there's always those clients that really want a deeper dive on, how do I utilize these different trusts and, credit trusts and things like that. And so we'll be doing that. Probably sometime over the summer, and it'll be, summer of 2021 will be likely when that's released, or even fall of 2021. So keep your eyes out for that. Trusts, as you mentioned, can be created while you're alive, or they can spring forth from your will as well, right? So either or of both options, you can use them in both ways. All right, so talk about some of the whys, right? We talked about this already. Passing assets privately, I think, is interesting too. So one of the things I think people don't realize, some people are, who cares? Some people are very private, right? From what I understand, your wills are, the probate's public record, correct?
So the probate is public record. In New York State, it is. By public record, you'd have to go over to the court and look at it and look it up on a computer. I mean, it's somebody who's specifically going to look. It's not like you can look it up online or anything along those lines. But there are certain things that the court does not put out for public record, accountings and things like that. But your will and your petition for probate are, anybody can go into the court and look it up. So yes, that's true. So privacy is something of concern for certain people. That a revocable living trust does provide.
Protect assets from creditors. We talked about that. Those creditors can also be a nursing home as well, right? So it just depends on the type of trust. You got to be careful there, because I think
sure. And not only that, but these irrevocable trusts that I do for people who have a significant amount of wealth, the irrevocable trust does provide some protection from creditors, from lawsuits and things like that, just because your trustee is not you. They're not suing you they're suing you personally. So concerns like that are doctors have great, significant concerns for malpractice and things like that. So irrevocable trusts, not only the ones for nursing homes that provide asset protection, they provide some level of protection in those instances as well.
And you touched on this one already, protecting sometimes beneficiaries from themselves, right? I've got all three of these situations. I have, a minors of a trust that we're trying to protect. We have a spindrift children that we're using trusts to protect them from running out of money and blowing through it all. And then we have the addiction issue, which is actually sadly becoming a bigger and bigger issue.
I do. I get a lot of that.
Yeah, it's sad. It's just terrible that we have this epidemic and this opiate epidemic in this country, but we do, right? And we have to address that.
I have parents that frequently come in that say, I have one daughter that's great, but my other child has had an addiction issue, and maybe they're recovered, but they're still, leery of somebody receiving $500,000. What's gonna happen then? So that is a really valid reason to hold that money in trust for that person.
Absolutely. We talked about this too. In the event of a supplemental needs trust, we're going to use that to keep that money away from, actually being owned by that beneficiary, so that they can still qualify for all their government benefits, whether it's Medicaid or Medicare or, SSI or whatever, so that's important too. Controlling assets from the grave. I don't personally recommend this too often. I think you run into a little bit of a dangerous scenario, but a lot of clients want to have a say, once they're gone, as to what this money is going to be spent for and how it's going to be used and who's going to be able to get access to it.
It's interesting. In certain circumstances, it's okay, right? So, I have some clients who are older who have younger children, right? And I don't love that they want to hold it in trust for 2 generations.
Right.
I'm going to hold it in trust for my child's lifetime and my grandchild's lifetime.
Yeah.
That's just, you don't even know that person. They may be terribly successful. They may, want that money to do something great with. You just don't know. Right. But, sometimes I put terms in trust. Trust sometimes, when people have a significant amount of wealth, it can lead to the beneficiaries becoming unproductive adults. Right. Yeah. Because they know that they always have that money to fall back on.
Right.
So I have written some trusts that have some interesting provisions, that say after 25 years old, my trustee has the ability to pay to that person the exact amount of their adjusted gross income on their tax return.
Ooh, I like that.
So
that's a great idea.
The kid's 25 and he goes and shows the trustee his tax return, and he's made $45,000 at 25, here you go. Here's 45 grand from the trust.
Right.
So it encourages some productivity sometimes.
Yeah.
So things like that are okay, but I really discourage really tight terms given to the trustee, meaning you can only have this money in these, 4 circumstances. You really want your trustee to have a lot of flexibility.
That can create some huge issues. I had a really good friend of mine in college, sadly, and he had his father passed away, and the money was went into a trust for his behalf. However, it gave the uncle, his father's brother, the total control over those assets.
Right.
And it didn't really specify how the assets could be used. It just listed him as control. So of
Right.
course the uncle used the assets for himself, and he never gave the assets like he should have. My friend in college, one of my fraternity brothers, he had to actually drop out of school because he couldn't pay his tuition anymore,
Yeah.
Michigan State, and then go on to fight a lawsuit to try to remove him. I lost touch with him after I graduated because obviously the financial business, you work pretty much 20 hours a day, 7 days a week, or you don't make it in our business. So I lost touch with him and a lot of other college buddies and whatnot. But I always thought that was so sad because here was a father who, family who had done a great job in accumulating millions of dollars. He was a Greek family, so a lot of family wealth that had been passed from generation to generation.
Yeah.
And
so that's more of an issue of choosing a fiduciary and not what the terms of the trust are. So a trustee can never, ever use the money for their own behalf. The trustee has a fiduciary responsibility to the beneficiaries, right?
Yeah.
So that's less of an issue of what the terms of the trust are and more of an issue of who you choose to be your trustee.
But how do you fight that though? Because honestly, not to get off on a tangent here, I know we have to wrap this up, but we had a situation in New Jersey where the trustee is absolutely not acting on behalf of the client. And
right. So,
but we've been unable to remove the trustee.
You have to bring a breach of fiduciary claim. And the trustee's obligated to provide an accounting to the beneficiary. And when I tell you an accounting, I mean it's like a super really
honestly, we haven't gotten anywhere in this situation. We've been fighting this now for about a year, and the accountant seems to be part of the deal. He's charging exorbitant fees, right? So it's like they're almost in cahoots with each other. So the trustee is paying himself out of the trust a management fee that's like 1%. He is, paying a ridiculous amount of accounting fees to the CPA, and I can't get anywhere.
So, those are things where when there's an accounting provided to the beneficiary, they have a beneficiary has, whether it's a revocable trust, whether it's a will, the surrogates court, in whatever jurisdiction they are in, has the jurisdiction to, object to that accounting, and they can be surcharged their fees and commissions, meaning they have to pay it back if it's unreasonable.
Okay. Well, I'm gonna have to get you involved in that case as well. See what you can come up with. That's basically to wrap it up. Any last tips that you could provide that you think of that we may have missed today, Ellen?
It really depends. And one sort of thing that is really important that people sort of overlook sometime is family dynamic is really important, right? So, and who your professional is really important. And if you don't like the people you're dealing with and you dread going to the meetings with them, then they're not the right person for you to work with, and family dynamic's really important. You have to ask somebody about their family dynamic. Do your kids get along? Does this person not like this person? Is there going to be an issue with your tangible personal property? Is your daughter going to lose her mind if she doesn't get your engagement ring? Those are the sorts of things that you have to ask people, and sometimes it's uncomfortable. Second marriages are uncomfortable. Kids from previous marriages are uncomfortable, but it's things that absolutely have to be addressed. You can't just gloss over that kind of stuff.
Right.
So, and you have to be comfortable talking to who you're dealing with. So I tell people all the time, and it goes for me too, if you don't like me, if you dread coming to a meeting with me, then go find somebody else, because you have to really like who you're dealing with. And it's just, it's really important.
Well, for us, that's why we say, we are unapologetically conservative, because, we get to work with people that think like us all week long, because we want to, I also want to be excited about having that meeting too, right? I don't want to, as a professional, from the flipping the table,
where you're going to say something.
You're dreading coming in to see me, for sure, right? Go find a professional that you're going to be on the same page with. The relationship that you have with your attorney or your accountant or your financial professional is just so critically important that you guys are on the same page. And, for us, we always say we the best job in the world, because we get to work with people that think like us Monday through Friday, but they probably think the same thing. Oh my God, I got a financial professional or a team of them that think just like me. And so we're on the same page, and that's really, really important, whether it's legal, financial, tax, or anything.
Absolutely.
Really.
And we're professionals. We don't take offense. If somebody says to me, I think I'd be more comfortable with somebody else, fine.
Yeah, no problem.
I mean, we're professionals. We can take it.
For sure. And it's got to be the right fit, and for us in our office, as most folks that work with us know, we charge, we're dual registered, but for the most part, most of our clients on an ongoing fee basis. So we're not charging an upfront commission, even though a lot of the work is upfront. We're charging an ongoing fee over a long period of time. So we're looking to engage in a relationship that's going to last for decades, ideally. I've got clients where I'm on the third generation, where I've been working with clients 20, 25 years. Now I've worked with their kids and their grandkids. And, some clients are 90 years old at this point. And I started working with them when they're 65. Like, how did that happen? But it does, which is good. Last thing just to wrap up here, as I mentioned earlier, we are a one-stop financial shop. The financial guys set out 20 years ago to build a firm where you could come in and get everything handled for you. We have offices in multiple locations, by the way, not just in Buffalo. We talked a lot about New York State law today because, Ellen, you're a New York State attorney. But we have relationships in South Florida. We have an office in Jupiter. We have an office in Rochester, New York. We have an office, obviously, in Buffalo, and a new office now in Batavia. So wherever you are, we can help you. But really, when it comes to financial planning and really all the things that we do, having a one-stop financial shop allows really your entire team to be working together. So we offer wealth management services. We do divorce planning. We have a certified divorce financial analyst on staff. We have 401k folks on staff. We have mortgage planning that we can do. Obviously, financial planning and retirement planning are our bread and butter. All of our folks are certified in what they do. So our Social Security planning team, we have certified Social Security claiming strategists. We have AHIP certified Medicare agents that can help you decide your Medicare. 40 different options in Western New York. It's impossible to choose between 3 of these things half the time. So, just know that if you come into our office and you work with the financial guys, we can help you from, insurance planning and life insurance and health insurance. If you retire early, let's say at age 60, but you have to bridge a gap, we can do that for you too. So lots of options that we have available. Use us as a resource. And just wanted to say thank you to everybody for joining us today. If you'd like to schedule an appointment, you can contact our office. Our office number is right here. We also have an 800 number, which is 833-FINT-GUYS. I should really put up on this slide. Or you can always go to our website, thefinancialguys.com. You can email us to our website. We'll respond same day. You can schedule appointments to the website as well. I would encourage you just to visit the website and find out all the different things that we do at our firm. But again, thank you so much for joining us today. We're looking forward to getting back to not live, but in-person presentations. These are always live, but in-person presentations where you can actually take questions from the audience. The question and answer part of the workshops to me is always some of the most informative, because sometimes things that we don't think about we get from the folks in the audience. We don't get the opportunity in a webinar like this, but we certainly do appreciate the opportunity to have a chance to talk to you today. And I hope you take a little bit of something away from this, whether you decide to work with us or you take it back to your existing professionals, just to make sure you update and you keep things in line. Our whole idea with TFG Academy is that a well-educated public serves us all. And so that's the idea behind these and why we provide this type of educational information on a regular basis. So for all the different TFG Academies coming up, again, please visit our website at thefinancialguys.com, and you can find out our winter schedule coming up very, very soon. So thank you all again. I hope you enjoy it and have a great evening.